The next matter is Shopping Mall NY LLC. We have the confirmation hearing on the third amended Chapter 11 Plan of Reorganization. We have the motion to estimate claim of Desiree Yagan for voting purposes. We have the motion for evidentiary hearing and motion for Rule 2004 examination, motion for adversary proceeding filed by Desiree Yagan. We have the motion to allow claim temporarily for voting purposes by Desiree Yagan. Ms. Weinrich.
Good morning, Your Honor. Sarah Weinrich here on behalf of the debtor, and my colleague Harry Greenfield is here as well.
All right. I see Mr. Greenfield. Who else is here on this case? Let me see. Ms. Yagan.
Judge, I apologize for the interruption. We were having some interference on Ms. Yagan's line, so I did mute her, but if she can just hit *6, she'll be able to unmute herself.
Very good. Ms. Yagan, can you hear me?
Yes, Your Honor, I can hear you.
All right. Anybody else want to enter their appearance? Right now we have Ms. Weinrich and we have Mr. Greenfield and yourself. All right. Let's start with, Ms. Weinrich. Your motion for the plan, I think, is a little bit contingent on Ms. Yagan's claim. So maybe we should address her claim and her issues first and then go back to your confirmation, unless you have some strong belief.
No, I would agree with you, Your Honor. I think that makes the most sense.
Goes to which I stated very clear, vehicular assault. The woman stated she didn't hit me. That's what it says in police report. She didn't hit me, and that I fell to the ground. It also states in the report, Your Honor, and this goes to the area of destroying evidence. I'm asserting to the court, which I can prove, that what the evidence would be and is of the vehicular assault is the surveillance video of the parking lot, Your Honor. I can only prove this in a Rule 2004 here examination, Your Honor, because I need them to produce the document that a videotape of the surveillance of the parking lot is cited in the police accident report. The officer states that he had the security for the Shoppingtown Mall reviewed the surveillance tape of the parking lot. There was nothing on it. Regardless of whether, but when I spoke to it, and again, this has to be shown by evidence, not just statements by me or the attorneys, but I will tell you, Your Honor, that the surveillance tape, it would require, they had to file an incident report or some sort of report with the insurance company. They have to preserve the videotape. I'm asserting to the court, there's never been an incident report filed. There is no surveillance tape. Or if there is, in the alternative, there is, no one would ever take my statement regarding it. They said there is no incident report. They even denied the security and the management, denied any knowledge of the incident. My legs were broken in the parking lot, Your Honor, and the Dewitt police refused to take my statement. When the police officer came, the woman runs her car into me from the parking space, accelerates from a standing position in the parking space, and runs her car. So the point is this, Your Honor, is that the video in the police report, which I didn't see for 4 weeks until it was faxed to me by the police clerk, James, and faxed it to me at Van Dyne Rehab Center, Your Honor, because I made repeated calls to the police department. You have to send someone to take my statement. Send the sergeant or the officer to take my statement. No one has taken my statement. I said it's a vehicular assault. I said I want the woman arrested. They wouldn't even take my statement. Now let's look at Shoppingtown Mall, Your Honor. When I called them, I wanted to give them my statement. I said, you have to preserve the video because I'm all about evidence, Your Honor. I'm very familiar with surveillance cameras, and I've done this, and there's one I upload on YouTube.
All right. I think that's fine.
I guess, Your Honor, the only thing I wanted to address as well is just the tabulation of the ballots then and how
Yes.
it might change. So let me check where I have the summary of ballots. So Ms. Yagan filed a proof of claim in the amount of $11 million. Certainly, if her claim is allowed in the amount of $11 million, Class 7 will have rejected the plan. We do not believe that's the case. And as I indicated in the ballot summary, unless Your Honor finds that Ms. Yagan holds a claim of $698,308.28 or more, that Class 7 will still have accepted the plan. And so in that instance, while she will have a claim at that point, the plan still could be confirmed over her objection or over her rejection of the plan. So then under 1129A2, requires that the proponent of the plan complies with the applicable provisions of this title. We believe that the debtor is in compliance with the Bankruptcy Code, and in determining whether the plan proponent has complied with the section, courts focus on whether the proponent has adhered to the disclosure and solicitation requirements of Section 1125 of the Bankruptcy Code. Plans that do comply with Section 1120, the plan does comply with Section 1125 of the Bankruptcy Code. On March 31st, at docket number 561, the court entered an order approving the disclosure statement. The debtor has complied with all applicable disclosures and solicitation set forth in the Bankruptcy Code, bankruptcy rules, local rules, and the disclosure statement order governing the notice, disclosure, and solicitation in connection with the plan and the disclosure statement. The disclosure statement, the plan, the ballots, and the notice of the confirmation hearing, all other related documents were distributed to the parties in accordance with the disclosure statement order. On April 5th, 2021, at docket number 565, the debtor filed a certificate of service indicating that all services were executed pursuant to the disclosure statement order. On May 6th, 2021, at document number 593, and then amended at document number 597, the debtor filed the summary of the ballots. And on May 3rd, at docket number 585, the debtor filed the certificate of no objections to the confirmation of the plan. We do recognize that Your Honor is considering Ms. Yagan's.
So, how much time do the parties need to prepare for this hearing? Ms. Yagan, I'm going to let you tell me first. I intend to hold the hearing no later than July. So, how much time do you need to prepare for that hearing?
Definitely as much time as I can be afforded by the court. So that's what I'm asking for.
Well, you can't have
June.
months and months and months, because this case we have to distribute to the other creditors. At this point, we want to confirm the plan and distribute monies.
Yes, I understand, Your Honor. It's important that, and I do understand. I am quite confident because I have reviewed the bankruptcy law. To answer your question, Your Honor, let's see. This is May 12th, and a month from today.
So you're saying you could be ready in June?
The end of June.
Okay. How do you intend to participate at the hearing? Do you have a capability to appear via video conference, using Zoom, or do you want to continue appearing by phone, or do you prefer to come to Pittsburgh to appear in the courtroom?
Your Honor, I assure you that I'm going. I will have a computer that will allow me to proceed on Zoom. Unless at that point that there can be actual physical appearances, because I certainly would be interested in that as the best form of the hearing for me in person. But if not, then the Zoom would be the next best method, and that will require me to obtain a new computer or something. But I will do what needs to be done because this is very hard for me to. I mean, it's all new to me and everything. But that I will definitely be prepared, and it will have, unless it's in person, where it's allowed to have actual hearings. And I suspect that we're getting there with COVID. But if the alternative by Zoom appearance.
All right. So you would be available. I guess your answer is by Zoom or in person. I don't know that we're going to be able to have in-person hearings in July, and that's what I'm thinking of this case, or end of June. As you indicated, you'd be ready in 30 days, so end of June, beginning of July. I don't think we'll be in the courtroom at that point operating without Zoom. So I guess we'll be in Zoom. Is that right?
Yeah.